all here. It's a very niche and interesting topic. I believe all of you are very much familiar with this domain itself. So, the objective of today's session is to take you all through the framework of sexual harassment of women at workplace. Act 2013, read with the rules. Now, wherever appropriate, uh, we will endeavor to share some best practices, some judicial precedents for a more comprehensive understanding of the law and the practice or the procedures it would entail. Because having sessions where you just tend to get to know about the law as opposed to some of those practical nuances, the strategic inputs is equally important for you because while you are vested with the powers of a civil court under the POSH Act, um, do you really have developed the ability to exercise those powers diligently and in an effective manner? Some of those aspects are very important for all of you to consider, and that is something which we are intending to cover. Now, of course, I think Anubhav has already mentioned there will be a Q&A session. You will have enough time in the end to ask those questions, but the request is that don't wait for the session to come to an end. You can continue to post any questions you may have in the chat box. We will continue to collate it. My colleague Diksha Malik is also there, who is also controlling the slide. She's collating. We will try to avoid any duplication in terms of queries. We'll try to collate and then address it. So the idea is that all the relevant aspects of this law are adequately covered. Now, moving on to the next slide. So the objective of POSH Act, as we briefly call it, is to prohibit and prevent sexual harassment committed against women and redress complaints and grievances raised by them in this regard. Now, POSH Act defines sexual harassment to include any one or more of the following acts which you see on the screen, whether these are direct or implied by nature: unwelcome sexual behavior, physical contact and advances, demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Of course, I'll explain some of these points as we move along in this session. Moving on to the next slide. Now, what we deduce from our previous slide, where you saw all these points uh, of what acts would amount to sexual harassment at workplace, the deduction here is that conduct must have sexual undertones or overtones. Now, this conduct should be unwelcome and it must occur at the workplace. Some of these aspects we will explain in greater detail, including what constitutes workplace under the law, whether there is an extension of workplace to any other premises externally, if there is an independent event that is organized, notwithstanding absence of any approval from the management, what happens then? We'll cover all those points because most of the questions would arise pertaining to some of those very interesting points. Now, if you look at the next slide, what behavior is inappropriate? Now, in this slide, we have set out few instances which may be deemed inappropriate. Physical conduct, that is touching, assault, pushing, petting, intimidatory behavior, violence. Verbal conduct, which includes insulting remarks, jokes, ridiculing, malicious gossip, offensive banter, even jokes which are targeting the concerned aggrieved women. Offensive jokes are instances which may likely fall within this domain. Sexual innuendos, you may have remarks or statements made in course of business, in course of meetings. Non-verbal uh, conduct. For example, exclusion. When I say exclusion, it is from office gatherings, it is in relation to meetings, it is in relation to any specific procedural discussions, discussions about operations. The person is targeted, she's excluded from some of those meetings or gatherings. Abuse of power, victimizing an individual, sending out offensive emails, isolating the victim, interfering with the victim's work. Now, all said and done, when we talk about what would constitute sexual harassment at workplace, it is equally important for you all to know what is not constituted as sexual harassment under POSH Act. On this slide before you, we have set out few instances that may not be deemed as sexual harassment at workplace. Uh, Differential treatment on account of other characteristics such as disability, gender, caste, religion. Now, all of these points is not what we are trying to imply here is that you cannot let the person go scot-free if there are instances where there is a differential treatment on these lines, because all of these are likely going to be covered under a separate policy consideration, which is your code of conduct or disciplinary policy. But this is not something which you ought to deal with under the POSH Act. Another instance is yelling, swearing, making derogatory comments, not entailing any sexual undertones. Now, again, some of these aspects may be dealt with under the company's code of conduct. Another instance is consensual physical or romantic relationship between two adults, not made on any false promise of promotion, increments, or career progression. So these are few of the instances which we wanted to highlight. There are precedents to demonstrate how the courts have also looked at some of these aspects and why the element of sexual overtone or undertone in any of these actions assumes significance. Moving on to the next slide, which is the extent or ambit of sexual harassment at workplace. Now, certain actions are themselves not per se amounting to sexual harassment, but when connected with sexual harassment, they are also prohibited and dealt with under the POSH Act. For example, promise of preferential treatment. For example, promotion in case a woman is involved in sexual relations with an employee. Uh, Threat of detrimental treatment. For example, no promotion in the event the concerned woman does not reciprocate the sexual advances. Threat against employment status, a threatened termination of employment if the woman speaks out against sexual harassment at workplace, uh, interference with work or creating a hostile work environment, humiliating treatment likely to affect health or safety. Now, to re-emphasize on some of these points when we talk about or refer to these in the slide, mere creation of a hostile work environment is not something which amounts to sexual harassment at workplace. The very concept of sexual harassment in a workplace against a woman should commence or start from an express or implied sexual advance, any action which contemplates sexual undertone or unwelcome behavior, which has a sexual tone behind it. So you cannot have any or all actions which may be coming in from the opposite side or the concerned respondent be treated or categorized as sexual harassment at workplace. So it is very important to see and be very purposive in your approach when there is a complaint which comes to the table or when you are approached by an agreed woman. Now, I would like to emphasize on some of the judgments which various courts have rendered from time to time and which are emphasizing on some of these aspects which I've just highlighted. Uh, in the judgment of KP Anil Rajgopal versus State of Kerala, this is a 2018 Kerala High Court judgment. It clarified that a solitary allegation of any or all of the acts enumerated under Section 3.2, which I just spoke about, cannot constitute an offense under the POSH Act 2013. Any such act should be connected with or in relation to an action or behavior of sexual harassment. So, in this case, the court also noted that any allegation of an incident that creates a hostile work environment must be in connection with an action or behavior which is sexually determined. Another important case is the Union of India versus Rema Srinivasan Iyengar. And in this case, sorry. So the Madras High Court in this case also noted that gender-based bias or favoritism not bearing sexual undertones or overtones would not be deemed as sexual harassment at workplace. So in case a complaint is filed in a manner that it entails both sexual harassment and non-sexual harassment related allegations, the internal committee may consider demarcating those allegations which prima facie demonstrate commission of an act amounting to sexual harassment at workplace and referring all other allegations to the appropriate department or committee or the nodal authority that has the designated power to look into other forms of misconduct. So, of course, when I'm suggesting this, all the honorable members sitting here, uh, please note that this should not be treated as a standard approach in all situations. Uh, for instance, both categories of misconduct emanate from a single incident such that the internal committee ought to look into the veracity of entire alleged incident, including the occurrence of a non-sexual harassment related conduct. And in these cases, the internal committee should look into allegations holistically to arrive at its finding, which may then be used by the disciplinary committee set up to determine any specific disciplinary action in non-sexual harassment cases, as if the findings were passed by the inquiry officer or panel. So, in majority of the instances, it is always advisable for you to not overstep the jurisdiction. You need to appreciate the fact that internal committee is vested with the powers to look into actions that are amounting to sexual harassment at workplace. It cannot be something which needs to be looked into by internal committee, which is connected with, let's say, service related grievances or issues related to performance appraisal, anything which is in relation to promotion. Of course, if the aspect of promotion or increment or incentivization is clearly linked to a threatened sexual advance or an inappropriate behavior which is unwelcome and it carries sexual undertone or overtone, in those cases, you have to look at it holistically. But otherwise, looking at a complaint which only talks about a service related grievance, just because it is coming to you, it is not something where you need to immediately initiate an inquiry. It's best to apply your mind to those scenarios and determine whether it is appropriate for you to take cognizance of that complaint and take it forward in terms of the next steps. So the next slide is pertaining to agreed women, because this is one of the most important definitions under the POSH Act, which pertains to uh, the process where, in order to file a complaint of sexual harassment before the internal committee, the concerned women may be of any age and need not be an employee engaged at the workplace. She could be anyone who has alleged to have been subjected to sexual harassment at workplace. So even if it is a volunteer, even if the lady is somebody who has been visiting the premises intermittently, somebody who has just been designated or deputed to render any kind of service, or even a maintenance job. Uh, it is not imperative for internal committee to consider only employees as agreed women. It could be anybody. But of course, what is important for us to appreciate is who can be the respondent and under what circumstances internal committee will have the jurisdiction to proceed with an inquiry against such respondent, that is the opposite party against whom allegations have been raised. Now, coming to the definition of respondent, a respondent is a person who is employed at the workplace, whether as a regular, temporary, ad hoc, or daily wage employee. Now, if you look at the premise of jurisdiction of internal committee, we move on to the next slide. From the definitions which we have just referred to in the previous slides, you would observe that internal committee under the POSH Act is specifically constituted to address any complaints by an agreed woman against sexual harassment at workplace. Now, very important judgment here. It is a Supreme Court of India judgment which made it clear in the case of Supriyo and others versus Union of India that women-centric laws that have been enacted in a specific historic, societal, and cultural context cannot be given an interpretation that goes beyond cis heterosexual women. Another important judgment of the Supreme Court in Binu Tamta versus High Court of Delhi, which held that definition of agreed women as it exists would not cover a person who belongs to the LGBTQIA plus community. Now, accordingly, I just want to explain this because in today's times, we have the DEI initiatives, we have extensive policies covering individuals from the LGBTQIA plus community, people who identify themselves as women or men. Now, in cases where some of these instances arise, you're receiving a complaint from somebody who would identify themselves as women. I would like to clarify that IC has jurisdiction to address sexual harassment complaints filed by those individuals whose sex is female. Now, this would include individuals who are born with reproductive organs and structure of a female, as well as individuals who have undergone sex reassignment surgery and now have the biological traits, organs, and structure of a female. However, this was not include men and individuals who identify themselves as female, but whose sex is not female. So this is very important. In today's times, you may have people coming in from different backgrounds. You have all these initiatives which are currently on the table, which is good for everybody. But from a legal perspective, please be mindful of some of these very important points. Because if you're approached by somebody who is only merely identifying themselves as a female, but some of these traits, the gender specific traits which I'm just referring to are not there, then you don't have the jurisdiction extent to look into that complaint. Now, of course, I'm not saying that if the complaints are received, these complaints should not be looked into. All complaints of sexual harassment made by individuals other than those whose sex is female against any other employee of the company shall be treated as misconduct and will be required to be inquired into in accordance with the company's disciplinary processes by a separate committee or separately designated body. So it's not that you have to just let it go. Even if you receive a complaint, there has to be a process attached to it, but it is not the internal committee which is authorized or designated by law to look into these grievances or complaints. Another important point, individuals other than those whose sex is female may also approach the complaint officer that has to be appointed by every establishment under the Transgender Persons Protection of Rights Act 2019, which also prohibits and penalizes sexual abuse of any kind. Now, this is a distinct law. It may not be as visible or as prominently talked about or spoken about as POSH Act, but this is indeed a piece of statute which is equally important, especially in today's context. Uh, the other point is about respondent, why we have spoken about agreed women. Uh, the respondent may belong to any gender in complaints before the internal committee. So it is immaterial whether the respondent is a transsexual or transgender, a person who is identifying himself as a female, or even a female employee or itself. All of them would fall within the definitional attributes of a respondent. Uh, in the matter of Malvika Bhattacharjee versus Internal Complaints Committee, it is a Calcutta High Court judgment in which the court observed that a cursory glance at the 2013 Act shows that the term respondent brings within its fold a person, thereby including persons of all genders. So, this is right opposite of what we have just explained in relation to agreed women. So respondents can be of any gender. It can be a female against a female. It can be uh, a transgender who can be the respondent in this case. But in cases where we have the agreed women, you need to determine some of those factors which we covered in the previous slide. Next slide. So while we have spoken about uh, definitional attributes of respondent, uh, agreed women, it is also important to understand what would constitute an employer. So, in relation to private sector establishments, the term employer has been defined under the POSH Act to mean any person responsible for the management, supervision, and control of the workplace. While few courts have taken the view that only the members of the board can be deemed as employer in certain cases. For example, Sneha Chaudhary versus Sahitya Akademi. This is a Delhi High Court judgment. It has been noted that when assessing the ambit of employer, the individual's day-to-day supervision and control over the workplace, where the women, the concerned agreed women, is engaged, assumes relevance. Of course, the employer has the power and obligation to constitute the internal committee. It is important to note that internal committee cannot inquire into complaints of sexual harassment against the employer itself. And of course, this is a subjective assessment. We cannot uh, define or categorize employer in just one bracket. But some of these tests which we have just mentioned are important for the internal committee to assess whether they have the jurisdiction to inquire into such matters which involve the employer itself. Now, the POSH Act provides for handling of complaints by the local committee, which is a government constituted body where no IC has been constituted due to presence of less than 10 employees, or the complaint is raised against the employer itself. Next slide. Now, while we have spoken about these three very important terms, these definitions that have been used under the POSH Act read with the rules, uh, it is equally important for the honorable members in this session to understand what would constitute a workplace, because this has been a contentious point, specifically in scenarios that arose during the pandemic. Now, the term workplace is broadly defined. It is not something which only covers the principal place of employment, but also covers any place visited by the employer arising out of or in course of employment. So, uh, any incident of sexual harassment against a woman employee by her colleague at a subject related seminar would fall within the purview of workplace. So if there is a training session, if there is a seminar which is being organized at a premise which is independent of or separate from the usual workplace, and an incident occurs, it would be imperative for the internal committee to look at these instances and treat that particular venue as a workplace. Now, one needs to look at several factors such as whether the victim or perpetrator was on duty, whether the gathering included employees, partners, customers, or unrelated third parties, whether it was a work event. Uh, Sexual harassment may also occur outside of normal working hours. So this is equally important. You don't have to just limit yourself within a scenario where an act amounting to sexual harassment has been committed only during work hours. It can go beyond it. Uh, Coming to the next slide, which is essentially a continuation of what we are discussing. Uh, One of the questions that has come to the forefront, especially, and I was just referring to the pandemic, uh, and the consequent emergence of remote working, is whether an employee's home can constitute a workplace within the meaning of POSH Act. Now, if you look at the provisions of POSH Act, the definition of workplace is linked to uh, the definition of employer, in the sense that an employer is one who is responsible for the management, supervision, and control of the workplace. Now, this seems to suggest that in order for a complaint to be entertained by the employer or the internal committee, the agreed women will have to establish that the place where this action or act was committed is one which has nexus with the employer, as opposed to merely having a connection with the work of the victim. Now, this view has also been taken by few courts. For instance, in the case of Saurabh Malik versus Comptroller and Auditor General of India, the Delhi High Court held that notion of workplace would not extend to those accommodations which may be far away from the workplace. The court approved certain important tests to determine whether a particular place is a workplace, such as proximity from the place of work, control of management over such workplace, or the residence where working women is residing, and see where such residence is an extension or contiguous part of the working place. So, the definition of workplace has been deliberately kept wide to ensure that any area where women may be subjected to sexual harassment is not left unattended or untouched. Because it is important to understand the spirit of this law. The idea is not to just shrug off the responsibility if there has been an incident that has been reported by an agreed woman, which has transpired or occurred outside the office premises. Now, a Bombay High Court judgment in Jaya Kote versus Rashtan Tukoji, it held that scope of employment must be interpreted as encompassing much more than a physical workplace, which we were just talking about, and should even include an artificial extension thereof. Now, in another judgment, the Rajasthan High Court has widened the scope of the term workplace harassment to include online harassment. It was held that digital workplace setting, it would be impossible to say that two people were not working out of the same workplace merely because they were located in two separate geographical locations. So this is very important. Work from home scenarios, Teams meetings or Zoom calls, an incident or a trigger transpires, a complaint is raised. It is important for all internal committee members to take note that just because it is happening in a scenario where individuals were working remotely, should not be a ground for the internal committee to not proceed with the next steps to determine the course of inquiry proceedings under the POSH Act. Now, moving on to the next slide, what is a workplace? Now, the question that may arise is whether a team retreat at a resort outside the premises of your official workplace and the retreat itself, which is not sponsored by the company, would amount to a workplace or not. Now, it is possible that such unofficial team retreat may amount to a workplace. Let's not completely deny the possibility of being compelled or constrained to categorize such place or premise also as a workplace. Uh, Conduct outside work premises may also be dealt with under the company policy dealing with disciplinary issues. And of course, it depends on various factors, including the impact of the conduct on working relationship between the individuals. So, the Bombay High Court, which has been rendering some of the most progressive rulings over the years, has held that question of whether an act taking place outside the premises of the workplace amounts to misconduct would be decided by seeing whether the act is directly linked with the general relationship of employer and employee or has a direct connection with or bearing on the contentment or comfort of the employee. Therefore, where the internal committee is presented with facts that demonstrate conduct outside of the physical confines of establishment, the internal committee needs to adopt a more purposive approach while interpreting the provisions of the POSH Act. So this is very important. You need to strike a balance. Not everything which has transpired outside the work premises would amount to an act which is falling within the domain of sexual harassment, but you cannot just let the matter go if you have done in your own way an inquiry or prelim assessment of whether it would fall within the ambit of workplace or not. So you need to clearly apply some of these tests to determine whether you have the jurisdiction that could be exercised to look into the grievances raised by an aggrieved. Now, the next point is constitution and remit of internal committee. Now, this slide is about the constitution and composition of internal committee. Uh, Going only by the letter of the law, one would be led by the understanding that every branch, unit, or office having 10 or more persons would be required to set up an internal committee. However, basis our understanding of the law and also interaction with governmental authorities in the past, uh, we understand that they are appreciative of practical challenges around such requirements, such as consistent application of principles governing internal inquiries. Now, as such, they are open to allowing for the concept of a nodal committee, which has the presence of representatives from different branches or offices. Uh, However, I would add that this has not per se been judicially tested. This is largely based on the comfort which the authorities draw when it comes to performance, when it comes to determination of what would constitute a workplace and whether the internal committee has the jurisdiction to look into those inquiry related aspects. Now, in the slide, we have also talked about the minimum number of members of an internal committee and the kind of qualifications that they must have. We have also added that the law expressly provides that an internal committee has powers of a civil code. I referred to this point in the beginning of this session. When it comes to requiring the presence of certain persons or production of certain documents. Now, that said, one limitation that the internal committee has is in terms of jurisdiction, and this is a very important point. They can look into complaints of sexual harassment which are filed by women alone. While you can have uh, a gender neutral approach, but this is something which is the constraint of the law. Complaints by persons of any other gender should therefore be treated under the general disciplinary policy of the organization. Uh, on these two slides, we are referring to the concept of jurisdiction of internal committee. Now, in these two slides, we have talked about jurisdictional aspects of internal committee in detail, since we have already discussed some of these aspects or most of these aspects in the previous slide. We will leave these slides for perusal of the audience later. I believe, Anubhav, this session is being recorded and we are happy to share the slides with all the members. So I'm not repeating the contents just to ensure we maintain brevity at all times. Uh, Moving on to the next slide, which is in relation to timelines, and one of the most contentious points, because in several instances we have seen that when observations and recommendation of the internal committee are called into question, the matter becomes imperative only because there has been an issue with the timelines that may not have been adhered to by the internal committee, or there are instances where enough and more opportunities have been provided to either of the parties to submit evidences, testimonies, or file additional details. And that has taken a lot of time, which has resulted in the technical nuance of internal committee inquiry proceedings having not been conducted in a timely manner. So, if you look at the slide, certain timelines are inherent within the inquiry process as envisaged under the POSH Act. The first one being submission of a complaint. Now, complainant must file the complaint within a period of 3 months from the date of. My request is if everybody can put this on mute, the mics on mute. So the complaint must be filed within a period of 3 months from the date of the last incident. Now, this period may be extended by the committee by another 3 months for reasons to be recorded in writing. Another important point is notice to the respondent. Now, notice should be sent to the respondent within 7 working days of receiving a copy of the complaint, and the respondent is required to submit written explanation against the allegations or grievances raised in the complaint within 10 working days from the date of his receipt. The timeline for completion of inquiry by the internal committee is within 90 days from the date when the complaint is received from the aggrieved woman. As regards the submission of report, it is supposed to be issued within 10 days from the date of completion of the inquiry. The employer is required to act on recommendations of the internal committee within a period of 60 days. And of course, last but not the least, if either of the parties who is agreed by uh, the observations or recommendations of the internal committee can appeal against such uh, observations before the competent appellate authority. Next slide. Now, I think one of the questions that have been raised is how do we deal with uh, anonymous complaints, whether we can really have the power to even deal with anonymous complaints or complaints that are in the nature of, let's say, a whistleblower. So all those aspects have been dealt with here. As I just said, you need to have the complaint in writing. In case the agreed women cannot file the complaint on account of her physical or mental incapacity, someone on her behalf may file such complaint with a consent. Uh, List of people are mentioned in the POSH rules, which include relative or friend, a co-worker, or any person having knowledge of the incident with the written consent of the agreed woman. So uh, this is something which forms the very basis of how a complaint could be received or how a complaint could be facilitated in case the agreed woman is mentally or physically incapacitated. Now, the complaint must disclose the agreed women's name, the respondent's name, and the party's working relationship. It should have a description of the incident or incidents along with date and timings to the extent possible. The courts in India have often held that there was no need for the internal committee to take cognizance of a woman's complaint when the same lacked details of the alleged incidents, including date and sequence of events. As such, the complaint should be specific and avoid vague allegations. So, this is important. Quick example, a complaint is coming to you, the internal committee has received it. The matter as it is set out in that complaint is an agreed woman saying that I have been sexually harassed. Now, this is a very wide statement for anybody to make. What is the actual instance? How and when? Why it has started? It's something which has got triggered. So all of those aspects are equally important for the internal committee to consider. Uh, the complaint should ideally be accompanied with supporting documents and list of witnesses. This is important because even from the viewpoint of principles of natural justice, you need to have adequate opportunity uh, given to the complainant or even the respondent to peruse the complaint in details, to have all the averments or allegations clearly set out. You cannot have instances where the complaint carries no details at all or partial details on instances that may have occurred, which is perceived as an act of sexual harassment by the concerned aggrieved women. So, all of these aspects are equally important. Uh, Another important point is conciliation. Now, IC may, before proceeding with the inquiry into the complaint, take steps to settle the matter by way of conciliation. If the same is, I repeat, if the same is requested for by the aggrieved women. So, conciliation as an interim step or as a preface to a detailed internal committee inquiry uh, is uh, is not something which is mandatorily required to be preceded by conciliation. The agreed women needs to request. Once that request is received by the internal committee, the process of conciliation could be triggered. Now, guidelines issued by the Ministry of Women and Child Development provide that internal committee must, before recommending conciliation, assess the severity of the situation and, if necessary, advise and enable the complainant to opt for the formal route. So this is again very important. As internal committee, it is not always about, let's say, settling the matter or brushing aside the matter, because in the longer run that becomes an issue. So this is something where even the relevant ministry has touched upon this important point as to why enabling the complainant to use the formal route is important. Now, the repercussions or result of conciliation process may include a written apology or transfer of the perpetrator or respondent. Once a settlement is arrived at, copies of these settlement will be shared with the complainant and the respondent. No monetary settlement shall be the basis of conciliation. I repeat, the money cannot exchange hands here. When we talk about conciliation, it is something which has been uh, put forth to facilitate those discussions. In certain instances, what has been perceived or reported as sexual harassment was only an issue which arose because of presence of another person. And in those instances, uh, having a conciliation process is something which is not advisable. You need to ensure that the request is coming from the concerned women. In certain instances, the question could be, what if the aggrieved women is not aware that a process of conciliation exists under the law? Our suggestion or advice will be that you may take steps to make the concerned aggrieved women aware that before you initiate an internal inquiry under the aegis of internal committee, there is a process which is set out under the law. Whether she wishes to or whether she wants to put in a request for conciliation is completely up to the agreed women. The suggestion should not come from you that why don't you go for conciliation. This is equally important, because if the women challenges that approach in the future, the internal committee will be called into question in terms of his conduct. One of the last important point is, once the parties meet for conciliation, one of the representatives of the internal committee, usually the presiding officer or another women member, is typically present as a neutral party to ensure that proceedings are in order and to guide the parties on the process if they need any kind of assistance. So that's something which is also important. And in case no settlement can be reached, then the internal committee must proceed to initiate that inquiry. Moving on to the slide related to principles of natural justice. Now, upholding the principles of natural justice is very important as far as internal committee is concerned, because we are a common law jurisdiction, and under all circumstances, this is something which has been emphasized on by courts from time to time. Now, the internal committee is required to adhere to the principles of natural justice during the entire course of its proceedings. And this would include seeking complete details from the complainant. Uh, Now, this has been affirmed by the Meghalaya High Court in the case of Professor Ashish Kumar versus Northeastern Hill University, providing the parties with complete complaint, counter statement, evidence, and witnesses statements. In case of Dr. S. Kannan versus Regional Cancer Center, the Kerala High Court emphasized the necessity for the parties having access to the material being relied upon by the opposite party. So, uh, providing counter statement, providing evidences, list of witnesses, all of this is as important as it is for the complainant to file a detailed complaint. Now, examination of parties and witnesses and cross examination amongst the parties is one of the most significant points. It is also a matter of consideration for the internal committee, because this question may keep coming up from time to time. In the matter of Manohar Dhonde and others versus State of Maharashtra, the Bombay High Court observed that in the absence of cross examination of any of the complainants or their witnesses, the inquiry and its report cannot be treated at par with the judicial quasi-judicial inquiry. It can be given status at the most of investigation or preliminary inquiry. Now, opportunity to object to internal committee's findings, which is highlighted in the second proviso under the POSH Act, under section 11(1), uh, access to the report and the material relied upon by the internal committee is equally important. Now, this has been emphasized under Section 13 of the POSH Act. Moving on to the next slide. Thank you. Now, another important point is requirements of a good IC report. Now, the internal committee, as a duly constituted collective body, ought to prepare its standalone consolidated report. Uh, in the case of Jaya Kotade versus Rashsan Tukoji Maharaj, the Bombay High Court held that while every member has a right to agree or disagree with the majority, a combined report indicating a collective application of mind is a must. Now, any report bereft of such joint deliberations is void, even if such personal report bears the signature of the concerned IC member. So this is very important. The intent must be to ensure that if the IC report is being issued, it needs to be issued under the aegis of uh, the joint deliberation by the concerned IC members. Now, the internal committee report should also mention the views of each of the internal committee members, unless there is, of course, a common view, along with submissions and evidence led by both the parties. So, in one of the interesting cases which we dealt with few years ago, um, surprisingly, we were in receipt of uh, three or four independent, different internal committee observations. And it was not just observation, it was a full-fledged report that was issued by different members of the board who were acting as internal committee members, and different members of the management who were acting as internal committee members. So, having a majority view, having absolute clarity on where things would stand when it comes to matters which are covering investigation into sexual harassment at workplace. Now, having talked about definitions, having talked about some of those practical queries, the issues that internal committees may face from time to time, it is also important for us to look at some of the scenarios and probably determine whether some of these instances, and just to let you know, interestingly, all the questions or scenarios which you see on the screen are essentially emanating from real life cases we have dealt with in the past. So we thought it best to just bring it out in terms of an example about certain scenarios as to whether this would amount to an act amounting to sexual harassment or not. Now, uh, if you look at the screen, the slide before you, the scenario, the first scenario is about two college friends, a male and a female, who have known each other for long and continued their friendship in the workplace. They happen to share jokes with each other. One day, the conversation turns sour between them due to certain jokes passed by the concerned male. Now, the question is whether this may amount to sexual harassment. Uh, any of the any of the members who are attending the session, I'm happy to hear your thought perspective on this scenario before I clarify whether it really amounts to sexual harassment or not. So
Yeah,
I'll quickly
yeah,
cover this point.
yeah,
I'll,
probably. Okay.
sorry.
Yeah, probably it may turn to be sexual harassment,
Sure.
although they had been friends earlier.
Right.
But to us, it looks like an apt
So,
case
ma'am,
for.
I think you are right.
So,
This may amount to sexual harassment, but important point again here is that just because they have been offensive jokes may not necessarily mean that those jokes or such actions may amount to sexual harassment. You need to see whether some of these offensive banters or jokes, even between colleagues who have known each other for a long time, would carry those sexual undertones or overtones in those concerned statements. So it is more of a subjective assessment, but this scenario may likely result in determination of an act of sexual harassment at workplace. The next scenario where the person ABC he's putting up sexually suggestive posters and drawings on his desk. You have those cubicles, you have open plan offices, and people tend to have some very fancy stuff on their boards. Uh, and in this instance, where we have also advised, another organization in the past, where this person was putting up suggestive posters and drawings on his desk board. Uh, the colleagues of that person, they kept telling him that it makes them feel uncomfortable. However, the concerned person claims that this is my dashboard and I have full right to put up whatever I want, and this is my personal space. So, and just to let you know, the colleagues are all female colleagues. They are sitting right across the table or right across the desk. The person very confidently is claiming that this is the person's space. Nobody should be feeling offended. So, in this scenario, what is your view? Any members attending the session? I'm happy to get their views.
So I'm Renu
Yes,
here.
yeah.
I think it is because
Yes.
Yeah.
it's a workplace culture, and it's a workplace for the female employees as well. And the organization is required to make the workplace a safe workplace for them to, work with respect and dignity. So I think this is a case of sexual harassment.
Absolutely. So just to again emphasize, some of the obligations of the employer is to facilitate a gender-sensitive workplace environment, and not just because the posters are not directed at let's say a specific female colleague, even if it is making women colleagues in general uncomfortable, it is very much an act amounting to sexual harassment.
Yes, sir. It is sexual harassment in my view because it is not his home. So that is not called his personal space.
Right, right.
So
Even at home, we must maintain the dignity.
yes, yes.
Why not at home?
It is a public place, so he had to refrain this sort of activities, sir.
No, even at so just to add there, even at his residential accommodation or wherever he is connected with the workplace, let's say there is a Teams or Zoom call which is going on,
It is not
and
never allowed.
yeah,
Not
so
allowed,
so
not
even in
allowed.
those cases, having gestures, and you will find some smileys or some other figures which are really coming up as part of those discussions. Some cartoon or some other animated videos are being played, and we have seen those instances. Person who is working remotely from the confines of his home, saying that this is my personal space while he is connected with colleagues who are reporting from a different location. Even those instances will be amounting to an act of sexual harassment, of course,
It's a
subject to due
indirect,
investigation.
sir. It's a indirectly act, indirectly, deliberately, indirectly act. I think.
Yeah, so both indirect and direct actions are covered, ma'am. Anything which is offensive carries sexual undertone or overtone, and something which has been reported and not even specifically targeting a specific female employee. The complaint has come in from other female colleagues or people in general who belongs to the female employees category. These are all actionable complaints. Internal committee needs to look into it. Determination of those actions as sexual harassment at workplace, whether it is indirect or direct, that is subjective. But yes, all of these instances would fall within the domain of POSH Act. Uh, Another scenario, the third scenario, DC compliments his female colleague, AD, only once by saying that is a nice sweater, but the size is not correct. Now, there's no bad intention, but AD accuses him of sexual harassment. So, in this scenario, what is your view? Because whether this is bringing out a very clear picture for you to form a prima facie view. We have just touched upon some of these points, so just thought it best to bounce it off through you people who are attending the
No, it's
session.
not.
In this case,
No.
the intention doesn't matter at all. It is the perception of the female which has to be taken into account. So,
Right.
I mean, I understand if it's a one-off comment, which has got a little bit of sex undertone. That's a nice setup, but the size is not correct. I think the intention is not relevant, but maybe the conclusion that if there are no further acts, it might be a case wherein it can be let off by a simple, a mild verbal warning
Sure.
also.
Sure.
Yeah.
Sure.
I think in this case, we have to also see the past also. The context is very important, whether there are any undertones or overtones, we are not aware of it. Intention, we don't know. intention can't be, we can't decipher from the statement.
Right.
But at the same time, if the female felt bad about it, we have to probe further that in the past, did they have any kind of interaction in which she heard some gestures or whatever. So I think this has to be looked into. Yeah.
So unless there are additional facts which will be of relevance, uh, just because the statement has been made by the concerned respondent, you cannot just have a very clear prima facie view that this is indeed sexual harassment at workplace. So absolutely right. I think the clarity is very much there on the table with all of you that this is something which will be subjected to further inquiry. And once facts are clear, you need to look at even the background or any occurrences in the past to determine whether this statement carries the status of sexual harassment at workplace. Now, coming to another scenario where Mr. O passed sexual slurs against her colleague. Uh, O passed sexual slurs against her colleague P on 19th May 2024. Now, on 19th June 2024, he filed a complaint of sexual harassment against O, who was serving her notice period at that point, which would end on 18th of August 2024. So this is slightly technical, but in these scenarios where the person is likely on her way out, whether internal committee will have the jurisdiction to entertain this complaint and inquire into it.
I think so, yes, because the on that particular day they both were employees and it was a workplace. So if it happened in the workplace definition, whatever, hotel or wherever it was done, the act happened. Yes, on that day, since they both were employees, this is definitely the committee, the POSH committee of the organization have to take this case into consideration. If the person accused is on the way, if the accused is serving notice period, then maybe the organization can also extend the notice period. In this case, the complainant was serving notice period, and she may say, okay, tomorrow onwards, I'm not coming to the organization, but it is the onus of the organization to
So in this case, it was O who was serving her notice period at the point which would end on 18th August 2024. So it is O who is the respondent, not the complainant. But yes, while talking about an extension of notice period is something which one needs to deal with. The important point here is that yes, O remains an employee of the company, and until she remains the employee of the company, the internal committee has the jurisdiction to take cognizance of the complaint filed by P. And if there are any actions that are recommended or observations set out in its report by the internal committee, then of course, until the time O remains as an employee of the company, such recommended actions can be contemplated from POSH at standpoint.
And since this is being the complaint is being made within 3 months, so that can be made under the POS Act. But if it's more than 3 months, I think then it cannot be done in the POS Act, right?
No, absolutely right. There is a timeline of 3 months, but there is an additional extension also which is provided for under the law. So I think so. This scenario was not in relation to that limitation period, but just to let that point be clarified, 3 months timeline is not something which is sacrosanct in law. Courts have time and again held that internal committee should not be acting mechanically just because a complaint has been raised or issued by the complainant, which is beyond that limitation period. You can always have a additional extension of 3 months. It can even go beyond it in certain instances, but those reasons have to be recorded in writing as to why the internal committee feels that to meet the ends of justice or to meet the objectives of the law, it was considered prudent by the internal committee to take cognizance of the complaint, albeit despite being filed quite late and beyond the limitation period. So just to let you know, while technical grounds do exist where internal committee can reject the complaint which is coming in beyond the limitation period. But just be very mindful that whether such complaint is a culmination of multiple instances of actions that may amount to sexual harassment at workplace, whether the concerned complainant had the necessary wherewithal or the strength to speak up, because in many instances you will find that there are genuine cases where the concerned female employee or the aggrieved women did not have enough strength to really come forward, and only after much deliberation the person could gather the strength to come to the internal committee. But again, all of this, if at all you are exercising that discretion, or you are exercising your power as the internal committee to extend it, the limitation period, then please record those reasons in writing, so that if at all the observations or recommendations are called into question or appealed against, then the respondent should not have a cogent ground where, while internal committee has gone beyond the limitation period to take cognizance of the complaint, there is no reason per se which has been recorded in writing. So just take care or be mindful of those aspects.
So,
I'm
just,
Sorry.
I just,
yes.
I just want
So in this
to follow up.
case, for extension of time, IC can think about the extension of time directly, or they have to take permission from the competent authority.
No, there is no permission from the competent authority.
IC
Internal
can decide
committee,
their own. IC can decide their own.
yes, IC can decide, but as I said, it cannot be the norm that every time a
No,
complaint
I
is received.
understand. I understand.
But
Yes.
otherwise, you're absolutely right. You don't have to have any prior approval from the competent authority. Internal committee itself carries the status of an independent collective body within the establishment itself. You don't need an approval from the local committee, or you don't need an approval from the district authority. You can do it on your own, but for reasons to be recorded in writing, the reasons have to be cogent enough to ensure that if at all you are called into explanation as to why such step was taken to accept the complaint which was filed beyond the limitation period, then the competent appellate authority needs to look into some of those reasons and not to reject your recommendations merely on technical grounds.
I understand.
Off कर दीजिए.
Now, another scenario, Nayak is a vice president of sales and marketing at a company. Sorry, I'm not taking any name.
The female
Mr. N
not
is a vice president of sales and marketing at a company. He's known to get extremely tough with non-performers and subordinates in his team. During a meeting, he scolds and mocks his female subordinate for a performance in front of the entire team. Is this something where the internal committee needs to take cognizance of whether this is something where POSH Act provisions are going to be applicable? How do you deal with a scenario of this nature?
No, I think it is more about the manager's behavior, about how to conduct such meetings firmly and politely with respect. So maybe he can be given some inputs around that, but this is not a case of sexual harassment.
In the absence of, so yes, absolutely right. In the absence of sexual undertones in the statements to his female subordinates, merely because there is scolding and mocking behavior, of course, the person needs to be or can be counseled. There could be a breach of code of conduct, how to really maintain your demeanor at workplace. This could be an issue which needs to be dealt with by the other competent designated authority, but not internal committee. Now, another important scenario which we have dealt with in the past is on a Sunday, while on an official video call with team members, VB felt that, in her opinion, DP came improperly dressed, making VB very uncomfortable. Now, DP says that at home, he always wears shorts and there is nothing obscene about it. So
In this
whether
case,
it is a Sunday
it's-
or whether it is any other day, the person is working remotely, just to, again, give a slight twist to it. and the point is about somebody who is wearing shorts or is not dressed very properly in accordance with the company's dress code during official calls, and this is something which is making the other party very uncomfortable. Whether this is something which is fit to be taken cognizance of by the internal committee.
Yes, yes, I
Yes,
think before
yes.
it was an official meeting, even if it was Sunday or a holiday, and this guy was in remote working, which added more, base to this understanding. And third is the feeling of discomfort by the colleague, female colleague. These three are good points.
So
I think
Anshu,
that this cannot be done under the POSH Act, but rather some other company policy, some
Yeah,
warning or some advisory need to be given to the employee, but not
yeah.
under POSH Act. I think so.
Yeah,
so
because
Yeah.
see, it could be a thin line, unless and until it is determined that merely wearing shorts while having a video call with your colleagues is amounting to sexual harassment, the answer will be no. But yes, if this is something which was really coming out as being done with an intent, or not exactly an intent, but really something which is resulting in a clear sexual innuendo against the colleagues who are on the other side and reporting to that individual, that could be a different scenario. But yes, the latter point which you just raised is absolutely right. There are policies to cover these instances where whether it is at workplace in physical presence, or whether it is working remotely, appropriate and adequate dressing in accordance with the organization's dress code is equally important. And if there is a violation or breach of such provisions, then the person needs to be acted against in accordance with that policy or protocols which are established by the organization to cover these points. So it may not always be the case that it is entirely covered or taken cognizance of by the internal committee.
But his
But I
dress
would
makes
add
her
that I
uncomfortable.
believe that,
Yeah,
yeah,
Sorry.
I
actually,
also believe.
it's not only the dress, the short, which is, but the way the person is sitting or lying. And many a times we have seen people, lying down on bed and attending to meeting. Those are also very offensive. So at times it is the body language, the way you are sitting, or things like that,
Right.
along with the dress, of course, that matters a lot to us.
Absolutely, all subjective. This is only a scenario,
Right.
completely dependent on whether this is discomfort is coming out only because of shorts, or it
Yeah.
is also something where there are, as I just mentioned, innuendos or actions that are
Right.
clearly demonstrative of those actions which may amount to a sexual overtone or undertone. So that's subjective assessment, but per se, it may not always be the case that dressing in dressed in shorts may amount to sexual harassment at workplace. But otherwise, completely with you. This is a subjective assessment. Uh,
Of course.
the
Anshul,
other
Anshul,
point, sorry,
Anshul, I just
yeah,
want to spend a couple of minutes on this
Right.
aspect.
right.
The intention of the respondent or the perpetrator is not relevant under the POSH. It is
Correct.
the perception of the female which is very relevant. I mean,
Important.
as you rightly mentioned, just because the person is wearing shorts and it happens once, it can be taken lightly. But if I mean, I'll give you a live example, a couple of live examples.
Right, right.
So what happened in this case was there was this person, relatively senior, who had this habit of putting his hand on the shoulder of every female that he would be
Mm,
conversing with. Now,
right.
some of the females were fine with that with the gesture, and some of them were not. And when there is a complaint, we looked into it and we counseled this person. And this person explanation was that, look, I do it with everybody. I have no foul intention. I just do it with everybody.
Mm,
So why is it that it is the issue?
yeah.
And we had to clearly tell
Yes.
him that it is not it is not your intention which matters here. It is the perception of the female. It is the discomfort of the female which matters. And the live example was that in particularly in MNCs, when you have a lot of foreign visitors, they usually have that they have a peck on the cheek when they meet.
Mm, mm. Sure.
Okay,
Yeah.
so whenever I used to have visitors for foreign visitors, particularly male visitors, I would immediately tell them that that's not a culture in India. You must not do it. I mean, and their immediate explanation would be that, but that's part of a culture, we do it. I said, not in India. If a female feels discomfort, you will fall under the ambiguity of the law. So therefore, these are some live examples wherein
Yes.
the perception of female becomes very important while you are investigating a POSH complaint.
Right.
तो फिर डिस्कशन हुआ
Absolutely.
तो ये हुआ है कि अभी अभी आप बात कर लेंगे
Right.
आपको 40,000 का लेंगे, बाकी जो एग्रीमेंट है ऐसे थिंग यू विल
Now,
गेट द यूजर एग्रीमेंट.
another scenario which is in relation to two colleagues working in the same organization, N and R. They travel for a team lunch together in N's car. Now, during their conversation, Mr. R asked her how she manages her home and her child after the loss of her husband. He then asked her how she manages her physical needs and mentioned that he could support her for anything that she may need.
अभी मैं एक सर से बात की
So,
कॉल
any
करने वाला.
answers? I
Yes.
think
Yes.
Absolutely sexual harassment.
Sir, it's a clear case.
Absolutely.
We just want some favor from her.
it's a slam dunk. I would say an open and shut case where a statement is made,
Yes.
clearly having a sexual overtone, not even an undertone.
Yes. Then
Yeah.
clear case.
And I think this is also done under the garb of sympathy, because he started by saying that, how's your family without your husband and so on. So just to create
Yeah.
some sympathy, and then, so it's a very, very, very clear case of sexual harassment.
Sexual
where the
harassment.
girl-
So the term physical needs has been.
It starts like that.
Yeah,
you
the
know,
term
showing some-
physical needs has been spelled out. So that also,
Yes.
it's a very clear-cut case.
Correct. Absolutely. You're spot on. Thank you. Now, last scenario is Miss P files a complaint before the internal committee alleging that Mr. A, the reporting manager, has a habit of calling her after work hours, and when she misses his calls, he does not really respond to her emails the next day and escalates the matter to his senior.
No,
So-
no, I think it's a during course of his employment. I don't think so. It comes under the sexual harassment.
I do come across these kind of cases where male counterparts are making calls on flimsy issues of relating to work, of course, at late night, so on and so forth, to the youngsters many a times. Now, to me, it is definitely going to it causes harassment, mental harassment, inappropriate timing for the person. You see, it's not a production unit where the things will be hampered. So that could have waited. So probably this is beginning, which will definitely result into those kind of intentional harassment. Intentionally, the person will be, not taking calls next day, so on and so forth. I build a case. Build a case. If is not getting satisfied sexually, we can call it. Then he will make a disciplinary case out of that against the lady. Quite possible.
Yeah, and also it's written that he has a habit of calling her after work hours. So this habit needs to be rectified.
Checked. Yes. Very correct.
Yeah. So I
Once
think
in a
see, the
while, it's okay.
question is the habit of calling. Of course, all of this needs to be dealt with because there are policies in this regard. Workplace demeanor is equally important. Everything is not sexual. So even non-sexual actions which are causing harassment are equally supposed to be dealt with. But it's just that you need to determine whether internal committee is supposed to be looking into those aspects, or whether it is kind of a mixed bag of complaints where one of these elements are coming to the forefront, whether it is a collective action on the part of the respondent, or whether this is an act in isolation where the person is calling late night, and whether only calling late night can amount to sexual harassment. The answer will be no. The only thing is calling late night beyond work hours for reasons which are not at all expedient or to meet the expediency of business. In those cases, you need to really have processes and protocols in place to deal with such scenarios where the person who is calling a female colleague on flimsy grounds, as you just rightly mentioned, that
Yes.
the person needs to be disciplined or those actions have to be rectified. The question was whether it is falling in the sexual harassment domain, subjective assessment, but per se, prima facie, it may not fall within the sexual harassment domain. But yes, as you rightly mentioned, over a period of time, things may transpire, and it is something which may result in any action which may amount to sexual harassment. So, yes, it needs to be dealt with appropriately and nipped in the bud. So, this is the end of all the slides here. Of course, we may have some questions. Diksha, we are collating questions, and I can see you are responding to some of these questions also. Anything which we need to take up?
I think maybe we can request members to chime in because we've tried to address all the questions that have been asked so far.
Sure, sure.
Anshul, one thing, if you can
but chat is
just
not
cover
available.
how the recommendations have to be dealt with. I mean, there's a popular perception that these are recommendations and therefore the employer may or disagree with those recommendations. So if you can just touch base as to how these recommendations are binding on the employer.
No, so the law is very clear, and there are enough and more judicial precedents also where recommendations as such are not just recommendations. Just to be very clear, we have observations and recommendations taken together. Everything flows in from the findings of the internal committee, and findings and recommendations coming together for the employer or the disciplinary authority to take cognizance of. It is not something where the employer has been given or the disciplinary authority has been given the discretion to accept or not accept. Of course, if there is anything which the disciplinary authority or management finds having been missed by the internal committee, or let's say a critical piece of evidence does not seem to be looked at by the internal committee, because of which the actions that have been recommended are not in line with the judicial perspective or the legal principles, then you can always go back and seek clarifications from the internal committee. But otherwise, to answer the question whether it could be a selective approach, whether you can say that this is not acceptable, I'm sending it back to you, the answer will be no. So recommendations are not just recommendations. These are very much findings and recommendations of a duly constituted statutory body. You ought to take action within the timeline that has been provided for under the law, but nothing stops you from calling some of the points or any points of clarification into question from IC's viewpoint. So you can always deal with that. And if at all internal committee noting some of those concerns from the disciplinary authorities end, will put down some of those premises in writing. And if at all it needs any rectifications or clarification, it may issue an amended or revised or updated report. That has happened in the past, but no discretion which has been vested with the employer or the disciplinary authority.
No,
And just
what
one more
if,
thing,
yeah,
if you can touch base on, is it a good idea to recommend the quantum of punishment also as part of the recommendation? Because I've generally seen that a lot of times the employer end up taking very disproportionate actions, and there's no consistency in the actions taken. So generally, I mean, we recommend that ideally the quantum of punishment could also be specified by the ICC to maintain consistency in the actions. That's generally a good practice. So how do you view this?
an extension of this question, do they work independently, the ICC and the disciplinary body, sir?
So I'll answer the latter question first. Yes, they are independent. Disciplinary authority and internal committee are not working together. Internal committees' obligations are very clear. They have to inquire. They have to give speaking order or speaking findings based on all testimonies and adducing all the evidences that are before them, giving the opportunity to both the parties to examine, cross-examine, or re-examine. Everything taken together, they have to give their findings, which are clearly set out on record. And basis that, the disciplinary authority or the management would need to act on those findings and observations and
That's
recommendations. So
mandatory? That
That's
is
yes.
mandatory to act upon the findings and reports submitted
Yes.
within the time frame, of course.
Within the time frame, but as I said, if there is anything which the employer or let's say the management or disciplinary authority finds lacking, or there is this a point which is not coming out very clearly in terms of his recommendations, then there is nothing which is stopping the employer from to seek clarity from the internal committee, but not to the extent of overturning or changing the full course of the findings of internal committee. That's something which is not permissible or provided for under the law, but nothing stops the employer from seeking clarity if there is any issue with how the findings have been arrived at.
So that
Just to
understand
supplement,
why the yes,
ma'am, in your case, particularly in case of BIT Mitra, uh, just to supplement what Anshul mentioned, the disciplinary committee cannot sit in the judgment of the ICC findings. They can only look at it and basis that take action. And in case they need any clarification, they can seek clarification. But for all practical purposes, ICC reports are conclusive. They
Yes,
cannot go
because the disciplinary action committee hasn't got back for any clarification. Therefore, we are a little inquisitive to know the fact. Yeah.
But I have one question. Still, I have one question. ICC can recommend the quantum of punishment or not? If the ICC members are having a common view, can
Right.
ICC say that the person should be demoted or should be transferred or something more harsh? Can ICC recommend these things?
Nothing stops the internal committee from making recommendations which are clearly setting out what should be the purview of that action as per the company's disciplinary policy or code of conduct. So the service rules will clearly stipulate what kind of punishment or punitive measures can be taken. So it's not that the law does not permit the internal committee to set out those actionable points for the management to take action on. So internal committee in most of the instances where we have dealt with clearly stipulate what the concerned or competent authority needs to do. So that's
And when
sorry.
to suspend the responding? If we have some amount of good proof of bad content, then can we recommend that the person should be suspended first?
During inquiry, we can
During
suspend
inquiry?
that respondent.
No, let me just clarify. First of all, interim measures under POSH Act are clearly stipulated. Suspension pending inquiry, because POSH Act and independent disciplinary processes are two different things. Of course, both would involve principles of natural justice, but interim measures are clearly stipulated under the POSH Act. You can disseminate, you can completely dissociate the concerned respondent from being responsible for, let's say, performance appraisal or assessment of the complainant. You can allow the concerned complainant to proceed on leave. You can have complete cessation of any reporting obligations for the complainant. The person himself can be moved out of the premises or asked not to report to work as far as vis-a-vis the complainant. So there are interim measures provided, but suspension as an interim measure per se has not been set out under the POSH Act as an interim measure. So what you can do is you can take interim measures as per the POSH Act itself, but suspension pending inquiry is something which is otherwise provided for usually under the Industrial Employment Standing Orders Act, which is applicable to workmen, or even otherwise for any other person who is covered under the disciplinary policy. You have suspension as an interim measure, not as a punishment. But under POSH Act, there is no such interim measure which is provided.
But there's a limitation to suspension as well. My understanding says that there is a limitation for suspension as well. Because,
so I think we are going beyond the POSH Act, but let me just explain. Yes, when we say limitation, I think it is directly drawing the corollary from the fact that subsistence allowance under IESO as payable to an employee in the first month is where you're paying 50%, then it increases to 75%. Then after completion of 3 months, when the inquiry has not been completed, it is a full pay. So all those instances, if you look at it, the whole premise is that you have to complete the inquiry within a reasonable time frame. You cannot place a person or keep him under suspension forever.
For indefinite time.
Yeah.
Of course.
Sir, my question is that if the recommendation sent to the employer and after 60 days no action has been taken and later on the employer has taken action, whether this delay to take action will be challenged before the court and what will be the court view? Whether court will set aside the order of the punishment on view of taking delay action?
See, ma'am, it's a very subjective scenario. I mean, if you look at it merely because 60 days timeline has elapsed, let's say another week has been taken by the competent authority to take that action. The court will obviously, if it is challenged, let's say the complainant challenges that no action was taken despite internal committee's recommended actions, then in those cases the court will ask a simple question: what was really constraining you to delay the action which was already recommended? And there is no cogent reason for the disciplinary authority to really put forth before the competent court, then it's an issue. But otherwise, we have seen instances where the timeline of 60 days has indeed been breached. But yes, the breach has happened because the disciplinary authority was also constrained to seek clarification from the internal committee on some of these points. And a lot of to and fro and back and forth was happening between the two bodies. And because of that, there was a delay. But yes, action was taken, albeit with delay. But yes, let me give you a scenario where action was taken almost after a period of 5 months. Now, in that case, the complainant was kept at high risk, despite the fact that the respondent was supposed to be facing immediate disciplinary action. But because no action was taken, despite the recommendation, and when the matter was called into question, the court reprimanded the internal committee as well as the management on the lack of absence of action on their part, despite everything being on paper. So those circumstances do exist, but otherwise, 5, 6 days here and there, for reasons to be recorded in writing, that's understandable.
Sir, another
Maybe just
question,
to-
maybe the last question. Sir, another question, maybe the last question. During the proceeding, should we have the cross interrogation? Like respondent and complainant both should be addressed simultaneously? Is it very essential?
The cross-examination point, I think we have covered this, but sometimes, ma'am, it may happen that the complainant or her witnesses may not be comfortable.
Yes.
Being physically cross-examined.
Yes.
So what I'm going to talk about is not a norm, but something which has been permitted by competent courts in some judicial precedents, and that is the interrogatory mode. And when I say interrogatory mode, this is a questionnaire which is put down in writing, and those questionnaires are exchanged by the parties without the need for them to face each other in person. Yeah, so that's something which is doable. Sometimes even it is anonymous. It is, you're not naming the witnesses to ensure that there is no reprisal or retaliation. But all of that you need to put forth very clearly in your minutes of the meeting, or when you are having those processes or proceedings initiated, so that tomorrow, if at all there is any question, then you have enough and more procedural evidence to demonstrate that you acted fairly and you acted in a manner where you wanted to meet ends of justice, to meet the objectives of the law.
Sir, just
sir,
one
I have a
observation. One observation. Suppose no action is apparently seen by the stakeholders, then the matter comes back to impression or perception about the ICC existence itself. How does ICC, put faith in the stakeholder or amongst the stakeholders? Little tricky situation.
No, I understand. It's a tricky one. You are absolutely right.
Yeah.
But again, I would like to say that the POSH Act, if you look at the preamble, it does not just talk about internal committee. It talks about the employer. It talks about the establishment.
True.
Now, it is a collective effort. It is not just the internal committee which is recommending actions. It is also the employer who is required to take or obligated to take all those actions which are which is resulting in a free, fair, and safe working environment for women. So if it is really seen or observed that despite recommendations to be put forth by the internal committee, the management is not taking any action or is like Daskal in their approach, despite IC's actions or recommendations, then is kind of a systemic failure of the establishment's machinery. And tomorrow, if there is a challenge or appeal before the competent authority, then it becomes an issue for the company itself. And more importantly, ma'am, it is not just about internal committee and the management. Your goodwill and reputation will be called into question, because in today's times, all these kind of matters, even if the name is not coming up to maintain confidentiality, but the organization's name is very much there in public.
True.
So, so is everybody is at a loss if something of this sort really transpires in any situation.
Thank you.
Just to address the VIT Mesra team, I know where your questions are coming from. Now, what has happened in the past. We are taking actions to course correct as to what has happened. So I think all your questions are relevant, but we are doing what we can do now in the present scenario, as we cannot undo the past.
True.
Thank you, sir.
Thank you so much, sir.
Thank you.
It instills confidence in ICC body, definitely. Thank you so much.
Sibi here, I have a question, I'm sure. So this is
Yes,
on the timeline of 90 days. So I attended various forums, and in some places it says 90 days means 90 working days, and in some places it says 90 days, which is calendar days. So far I have not got a very conclusive answer, because the parties who says 90 working days, they take from the stand that yes, the act doesn't say 90 working days or calendar days. But in some places they said, okay, you have to serve the notice within 10 working days, for example. So what they say is, in some places, since the working days is specified, in the entire act, it should be read as working days, which means 90 working days. And I am also aware of a very large company following this 90 working days model. So what is correct here?
sure, Sibi. Diksha, you want to take that question?
Sure. So Sibi, just to answer that question, the basic principle of law is that if a certain word is used in one particular section but is not used in another section, it means that the law consciously omitted that from one particular provision, right? So when we talk about the 7 working days concept, it is expressly mentioned as such under the law. There's an express use of the word working days when we are talking about the 7 working days concept. But when we are talking about the 90 days framework, there is no such express reference under the law. So the interpretation that I was talking about, that that the law consciously put it at one place but did not put it at another place, means that the intention is to talk about 90 calendar days. Organizations definitely have their own policies, etc. in place, but how that will be judicially tested is another thing altogether.
So for all practical purposes,
Are there any cases, are there any instances where this is interpreted by any of the courts?
So whatever cases we have seen, the emphasis is always on calendar days. We have not seen an instance where working days concept has been followed, simply because the law itself doesn't use that phrase when it comes to the duration of inquiry.
it may not have been tested under the POSH Act, but it has been tested multiple times under various other legislations.
Yes.
The concept of working days
Sir, I have a question.
that is defined.
Sir, I have a question regarding the evidence. I had put it in the chat, but I couldn't get the answer. So that's why I'm asking. Regarding the time of verbal conversation, verbal harassment, like the superior person asking, do you have a boyfriend? Or are you in the dating app? Or I'm free in the weekend, are you interested? Things like that. When they ask, normally there won't be a third person. So, and the complainant is not able to record whenever these chats occur. So in that case, what is the evidence that we expect, ICC expect, or is that just the statement by the complainant is enough?
So, ma'am,
These questions are clearly come under harassment, right?
no, see, do you have a boyfriend? Of course, the senior concerned has got should not be having any concern with the personal life of a female colleague. And is clearly making somebody uncomfortable. It is prima facie something which is falling within the domain of sexual harassment. But to answer your question about evidence, again, very subjective, but just to ensure that we are very clear on the basic premise which should be followed when you are inquiring into actions amounting to sexual harassment at workplace is preponderance of probability. Unlike within the criminal law domain, where beyond reasonable doubt is the first premise, here we are talking about what may have transpired and what could be the probability of such actions having been uh, taken or perpetrated by the respondent. So you need to look at all the mitigating circumstances, not just one statement, but what may have transpired, the reporting relationship, the overall conduct of this individual, the general background, where things are coming from. Are there any other aspects where this kind of a complaint has been made without any corroboration whatsoever? So yes, the statement definitely would matter, but you need to be slightly more purposive in your approach to determine whether this is clearly falling within the domain of sexual harassment at workplace or not. Prima facie, it does, but to ensure that any recommendation on the part of the internal committee also follows the principles of proportionality. These aspects are equally very important, but otherwise it's very subjective. I cannot really compartmentalize this answer into just one bracket, but this is where you stand as internal committee members.
Just to clarify, in one of the instances, a very disproportionate action was taken by the company. I mean, the findings of the ICC were, inconclusive. The allegation itself was so meager in nature, and the employer went on to terminate this employee. And obviously, this employee challenged the termination, and therefore we are in a difficulty wherein we won't be able to defend our action because the proportionality of the punishment given was completely in disproportion to the either to the nature of the allegation. Even if we assume that whatever was being allegated was 100% correct, still a
Right,
mild
right.
warning would have been more than enough to kind of address those issues. So the punishment has also always been commensurate with the findings of the ICC, and therefore it is generally suggested that the ICC should also give the quantum of punishment
Yes,
in its report, so that there's a consistency of the action taken by the employer.
absolutely. Right. Okay.
So a related question is that, ensure, suppose if IC recommends that, okay, we find the gravity as serious and termination is what we recommend. And when the management reviews, they find it okay, as per the various policies, maybe code of conduct or disciplinary and all. It says maybe the severity of the action doesn't warrant termination. So can they go back to the IC, or can they voluntarily take a decision that no, we will not terminate, we may take some
No,
other
they
action?
no, they cannot voluntarily or do anything. They cannot change the course of what has been recommended. But yes, as I said, if they have the question of seeking further clarity, they can always go back and seek that clarification from the internal committee. But if the recommendations would stand, and as I think Manish was just mentioning, if the principles of proportionality have not been followed, then it is also IC's loss, because tomorrow, if it is called into question and appealed before the competent authority, it is very likely that the appellate authority is going to strike it down, or at least ensure that it is repatriated back to the internal committee for a fresh consideration. So that's why, but otherwise, management does not have the discretion or power to overturn or to say that you have recommended A, but I am taking action basis B. That cannot happen.
Okay.
So I
Just
think
to just to supplement, in this scenario, the relevant recommended action would be for the employer to go back to the ICT, tell them of all the rules that they are referring to, and as to how, in their opinion, this should not be a case of termination. Let the ICC consider all that material, and either they stand by their recommendation or they change their recommendation.
Yep.
So at the end of the day, whatever action has to be taken, this has to be as per the final findings of the ICC only. The employer, as already pointed out, Anshul, does not have any discretion in this.
I think to avoid such confusion, the standing orders or the service rule must specify what are the punishment for which case, which fault, what is the punishment. So all this must be clearly written in the either in the standing orders or service rule to avoid such confusion, right?
Um, See, it is definitely there already in the model standing orders also. If you see, and some of the other state standing orders under applicable rules, you will find some of these instances which are covered. But again, to say that as a collective quasi-judicial or collective body within the organization as per the mandate of law, you need to really apply your mind and follow that principle of proportionality, because everything and anything, sir, cannot be really predetermined. Manish, correct me if I'm wrong, but no policy can ever give you a clear stipulation of how you need to act, whether it can be a verbal warning, whether it can be counseling, whether it can be something else, or a demotion or reduction in pay. You need to really act in accordance with how those principles have to be followed. And this is very, very subjective. Sometimes you have to be objective also to determine what should be the course of punitive measure. So while it is absolutely advisable to have as many circumstances covered under your policy document, but nothing can supplant your own application of mind when it comes to circumstances which may arise in the future. That's very important.
And Anshul, just to supplement, it is impossible to lay out the finite number of incidents and
Yes.
then accordingly decide the punishment.
Yeah.
Every case is unique. Every case has got its own facts and circumstances. So therefore, the application of mind by the ICC and reaching a conclusion and therefore deciding the quantum of punishment is like it has to be done by the ICC. You cannot quantify everything.
Right, right, right.
Non-implementation, non-implementation of the recommendation. So where do we feel it says the term tribunal or court? So high court, or which court is it referring to, or tribunal?
So,
Little clarity.
there are designated appellate bodies, madam, in different states. For example, in Maharashtra, it is the Industrial Court, which is otherwise set up under the MRTU Pulp Act. So by notification, the Maharashtra government has designated industrial courts in Maharashtra to have the power to entertain these appeals. And of course, there is a whole chart which we have maintained on who would be the designated authority in a particular state. In certain states, it is the local the deputy commissioner's office also, which has an appellate power. In certain instances, it is the designated industrial tribunal which has the power. So it completely depends. But when we say appeal, it is not the ordinary right of appeal as you would see in the standing orders, where you have an appellate or apex authority within the organization itself. So, that appeal cannot be the scenario under POSH Act. If there is an appeal, the appeal will be before the competent designated authority under POSH Act as notified by the appropriate government.
Sir, my question is that if respondent has not filed any appeal before the competent authority within
Yes.
90 days, he has not invoked that provision,
Right.
then what to do? We have to the employer have to wait. He have to file appeal and then we have to dispose the appeal. What to do if he has not invoked that provision?
No,
He
you
so
go
he
ahead.
found guilty.
So, Nidhi, the employer doesn't have to wait for the respondent to file an appeal. The ICC submits its finding. within
Yes, sir.
90 days and a copy is served to the both the complainant and the respondent, the
Yes, sir.
employer has to take action within 90 days. The employer doesn't have to wait for the respondent to see whether he is filing appeal or not.
Absolutely. Yeah.
You
Yes.
just have to go
60
through
days
your own.
timeline. You have a 60 days timeline. Now,
Yeah.
whether this person is going for an appeal or not, that is not your concern. So
Okay.
he can continue, he can prefer. You don't have to, nobody waits. I mean, it's just like for any other judicial authority. Manish, thank you for that. But any judicial authority is not going to wait. Of course, parties may request, but that's an independent mechanism. But here, if you want to take action, you have to take action within the statutory time frame. 60 days is there. Within 60 days, you have to implement.
Sir, in
As an
Jharkhand,
employer.
what is the appellate authority? Where is the appellate authority in Jharkhand state? Do you have any idea of that?
Diksha, can you just confirm that, or otherwise we can come back? We haven't really. If it is there in our records, we can confirm.
One observation, it could be possible for these are applicable to industrial units or organizations, educational institutions. Is it the same authority? We
No, so
will be
POSH,
happy to.
no, so
Yeah.
POSH Act is not categorizing any establishment within a particular sector, ma'am. Unlike,
Right.
let's say, Shops and Commercial Establishments Act, which tends to exclude educational institutions outside its purview. But otherwise, if you look at it from the perspective of POSH Act, even schools are covered.
This is one and the same. Yeah.
Yeah,
For,
so it's this.
in context of appeal, actually, I was wondering.
Sir, my last question is that if when we receive complaint, तो कंप्लेनेंट का जो स्टेटमेंट आईसीसी लेता है वो रेस्पोंडेंट के सामने होना चाहिए कि नहीं नेचुरल जस्टिस के हिसाब से सर दिस इज माय लास्ट क्वेश्चन
देखिए, होना चाहिए। कानून बोलता है, विधि बोलती है कि होना चाहिए, ठीक है।
यस सर
लेकिन ऐसे बहुत सी सिचुएशंस आपके सामने आएंगी जिसमें जो कंप्लेनेंट है वो कंफर्टेबल नहीं है, जो सामने वाला बंदा है वो पावरफुल है, हाई स्टेटस है, सीनियर ऑफिशियल है, महिला को ये डर लगा रहता है कि मेरे साथ कोई रिटेलिएशन ना हो, और कई बार बातें सामने नहीं आती, वो लेटेंट तरीके से उसके अगेंस्ट की जा सकती हैं रेस्पोंडेंट के द्वारा। तो ऐसे सिनेरियो में अगर आप चाहते हैं कि टू मीट द एंड्स ऑफ जस्टिस, तो ये हो सकता है कि जो मैंने आपको एक्सप्लेन किया, इंटेरोगेटरीज का जो मैकेनिज्म है आप फॉलो कर सकते हैं, जिसमें कंप्लेनेंट अपना स्टेटमेंट या अपने क्वेश्चंस देता है या रेस्पोंडेंट अपने क्वेश्चंस देता है। बिकॉज पहले तो सबसे पहले क्या होगा, कंप्लेंट रेस्पोंडेंट के पास जाएगी, रेस्पोंडेंट कंप्लेंट को देख के अपना रिप्लाई देगा, उसके बाद बातें सामने आती हैं, एंड नथिंग स्टॉप्स द इंटरनल कमिटी आल्सो टू रेज क्वेश्चंस, आपके अपने क्वेश्चनर होंगे। उस बात में बाद में जब क्रॉस एग्जामिनेशन की बात आती है तो आपके पास ये डिस्क्रिशन है। अगेन आई एम रिपीटिंग माई सेल्फ, दिस इज नॉट द नॉर्म, ये हमेशा नहीं हो सकता है, ओनली इन इंस्टेंसेस वेयर इट इज अ वेरी क्लियर सिनेरियो that a point of retaliation or threat of retaliation is perceived, and that threat which is perceived is very much valid, and the lady concerned is not. So in those cases you can have for reasons recorded in writing, allow cross examination without the person being confronting the respondent confronting the complainant.
But the matter is when challenged before the court, the only agenda is that कि natural justice का procedure नहीं follow हुआ है, so case में कोई दम नहीं है।
देखिए, दम ऐसे नहीं, दम तो ये नहीं होगा ना जब आप अलाउ ही नहीं करेंगे। मैं सिचुएशन क्या होती है, कोर्ट को ये भी देखना है ना कि आपने और क्या किया। एंड वी हैव सीन इंस्टेंसेस जहां पे अगर इंटेरोगेटरीज के थ्रू आपने क्रॉस एग्जामिनेशन अलाउ किया है मैडम, तो आप ये दिखा सकते हैं कि ऐसी कोई भी अपॉर्चुनिटी नहीं थी जो इनको नहीं दी गई उन क्वेश्चंस को पूछने के लिए। ऐसा क्या हो जाएगा कि अगर आप उनको सामने नहीं पाएंगे और अगर आप उनके बिना सामने पाए कुछ पूछ लेंगे, तो उन दोनों क्वेश्चंस में क्या अंतर होता है,
मतलब
ये बात कोर्ट को भी समझना।
क्वेश्चनर्स एक्सचेंज हो जाएंगे, और अगर विक्टिम कोई रिस्पांस ना दे तो
रिस्पांस नहीं देगा, देन अगेन you have a valid point. The court is going to say कि अगर response नहीं आया, then that means there is nothing which is actually being submitted in the form of a rebuttal. That is for any case where the defense is pointing towards the direction of irrefutable evidence. And if you're not able to corroborate your side of the story as a complainant, then of course, if there is any recommendation which is against the respondent, it is very much amenable to challenge before the competent authority. So this is a wheel, or एक जैसे बोलते हैं ना आपका चक्र है, इसमें तो जैसी सिचुएशन आएगी, क्या फैक्ट्स एंड सर्कमस्टांसेस हैं, किसको एड्यूस किया गया, किसका एविडेंस भारी था, सो यू नो देयर इज नो एंड।
एंड सर इन जैसे कि आपने बताया था कि पॉस में मतलब कुछ भी एक्ट्स दैट कम्स अंडर द सेक्सुअल हरासमेंट, समटाइम्स बिना लिखे बहुत सारे कंप्लेन मुझे आते हैं कि जैसे कोई गाइड ने किसी गर्ल्स स्टूडेंट को कहा कि वो तुम्हारी शादी हुई है, अभी प्रेग्नेंट मत होना, so that comes under the sexual harassment. The girl's PhD student is not ready to write down this thing. तो क्या हर एक चीज को एजेंडा बनाना है, या उनको पर्सनली काउंसलिंग, क्योंकि लड़की लिखने को तैयार नहीं है, या उनको कुछ काउंसलिंग वगैरह करके छोड़ दिया जाए? क्योंकि अगर हर एक छोटी छोटी बात को लेकर अगर कॉग्निजेंस लिया जाए तो काम नहीं करेंगे. एवरी डे देयर इज 10 केसेस इन बिफोर द आईसीसी. सर
देखिए, आई हैव क्लैरिफाइड दैट वर्बल कंप्लेंट्स, anonymous complaints, unlike the whistleblowing mechanism, which is under another, regulation for listed and unlisted companies or public listed companies, that's different. But I am talking about the POSH Act. POSH Act में clearly दिया हुआ है, complainant को disclose करना पड़ेगा कि वो कौन है, respondent को भी disclose करना पड़ेगा. All of that needs to be put down in writing, ma'am. अगर वो नहीं राजी है करने के लिए, then there is nothing which you can do or take cognizance of on your own. So
Nidhi, I can answer your question separately. I think if you have any specific questions, I think we can have a separate session on it.
Thank you, sir. Okay, sir.
All right.
Are there any other questions from anyone else?
Thank you very much for your thorough discussion and insights.
Okay. Thanks a lot, Anshul. Thanks a lot, Diksha. And I'd like to thank everyone for attending the session and make it quite interactive. Thanks to everyone.
Thank you.
Thank you. Thanks, Manish. Thanks, everyone.
Thank you.
Bye-bye.
Thank you.
Thank you.
Thank you.
Thank you. Thank you.
Thank you.
Thank you. Thank you.
Leave.
Leave, Pratika, leave.